Mr. Butler, will you require 10 minutes protection?
Yeah, I would appreciate that, Justice Kampepe. Justice Kampepe and members of the court, I'm going to deal with three matters. First, I'm going to deal with the remedy, the just and equitable remedy, if the termination of Mr. Nkosana's position and the appointment of Mr. Abrahams are set aside, or are invalid. Let me not say set aside, if they're invalid. If that termination and that appointment are invalid, what then? Secondly, I'm going to deal with the challenge to the validity of Section 12.4 and Section 12.6 of the NPA Act. And thirdly, I will address the question raised by Justice Kampepe at the outside, the issue of the absence of any submissions by the President or the Minister. So starting then with the assuming that there has been the court finds that the termination of Mr. Nkosana's appointment was invalid, what then? We say that the default position is that once the decision is made that the termination is unlawful, then the termination should be set aside, and the ordinary consequence would be a reinstatement. But that's, of course, subject to the court's wide remedial power, its wide discretion to make any order that is just and equitable. So the real remedial question is not what's the default. The remedial question is what would be the just and equitable order. We say, make the submission that there are some reasons to be sympathetic to the position of Mr. Nkosana. First, it seems clear that he was placed under great pressure to vacate or leave or depart from the position of NDPP. Secondly, the evidence strongly suggests that the reason he came under that pressure was because he was acting independently of the executive in the factional wars which were taking place in the NPA, that he acted according to what he thought was right, not according to what the executive wanted. Thirdly, there is the fact that he has come clean, made a full disclosure of what happened. Fourthly, he has stated that he will return the proceeds of the golden handshake which he received. But there are also, unfortunately, other undeniable and uncomfortable facts. Firstly, he turned to his own advantage the President's desire to remove him in order to extract a very large, unjustified and unlawful payment from the public purse. Secondly, he was an active party to the unlawful agreements. In fact, the ultimate terms of the unlawful agreement were dictated by him. He was the person who said what the amount had to be. Thirdly, he abandoned his constitutional duty as NDPP, not because he felt he couldn't do the job, but in order to secure the unlawful payment. And fourthly, he did nothing to reverse the situation until this litigation was brought sometime later. To say this is not to pass a harsh judgment on Mr. Nkosana. We're all human. But it is to say that it is impossible to deny that there is a question about whether he's the right person or suitable person for the position. And we submit that that's on that question it's not possible or appropriate for this court to come to any judgment about Mr. Nkosana's suitability for the position. Firstly, his suitability for the position has never been an issue in this case. Secondly, the result is that the court doesn't have all of the material which would be necessary to come to a fully informed judgment about what happened and why, and what the consequences are in relation to Mr. Nkosana. Thirdly, to the extent that the court does have factual information before it, a great deal of it is subject to disputes of fact, which this court would have to deal with on paper as the court of first instance. And fourthly, and most fundamentally, the judgment as to whether Mr. Nkosana is today a suitable person for the position of NDPP is best made by the person who's given that task by the Constitution, the President. The President decides who should be the NDPP. In addition, I have to say there's an underlying question which has been raised, I think, by Justice Kachalia about the validity of his appointment when the appointment of Mr. Bikoli was terminated under dubious circumstances. So we submit that the just and equitable remedy would be if the removal of Mr. Nkosana is found to be unlawful, would be to the court not to attempt to fill the post which he vacated by putting him back in, but to leave that task to the President, who would be entitled to appoint Mr. Nkosana or Mr. Abrahams or anyone else. That would entail the appointment of an acting NDPP, and I'll come to that in due course. The next question is then Mr. Abrahams. What about him leaving his post? Is it just and equitable that he should stay? Well, the first, again, the default position we submit is that if the prerequisite for his appointment, namely a vacancy in the NDPP, was in the position of NDPP, well, let me put it differently. The default position under the Constitution is that if Mr. Nkosana was unlawfully terminated as NDPP, then there was, as a matter of law, no vacancy into which Mr. Abrahams could be lawfully appointed, and his appointment should be set aside. That's the default position again. And in response to the question raised by Justice Madlanga about how this works, we submit that there's a helpful passage quoted from we refer in our heads of argument at page 73, paragraph 73, page 41, where we make the following submission. We say, the setting aside of the appointment of Mr. Abrahams is the default position. Where a public act is declared invalid, the ordinary rule is that subsequent acts that depend on the invalid act for their legality should also be set aside. As the SCA held in Odekral, quote, the proper inquiry in each case, at least at first, is not whether the initial act was valid, but rather whether its substantial validity was a necessary precondition for the validity of subsequent acts. Was the validity of the removal of Mr. Nkosana a necessary precondition for the validity of the appointment of Mr. Abrahams? And we say whether the initial act must be substantively valid or formally valid depends on the proper construction of the statute. We refer to Odekral and we refer to a recent article in the South African Law Journal dealing with that issue. So we submit that the default position is that Mr. Abrahams must vacate the post. Of course, this is subject, again, to the just and equitable discretion of the court. We say that the burden is on Mr. Abrahams if he concedes that it would be just and equitable for him to stay, to remain in the post. The burden would be on him to introduce evidence which justifies that conclusion. And there are really only two bases on which that might conceivably be justified. First, we say he produces no real evidence other than an ipse dixit. He says, things have settled down a lot since I got there. Well, that's never really been traversed in the papers because it hasn't been an issue in the papers. And it is, with due respect, difficult to know what is to make of that assertion that everything is now fine in the NPA as a result of Mr. Abrahams' appointment. It's, with respect, not something one can simply take for granted. I won't put it more strongly than that. But secondly, he certainly can't claim that justice and equity require that he remain in a job to which he was unlawfully appointed and for which he has been paid for the work has already been done. It's no different from any other person who gets, somebody who puts in a bid for a contract, gets the contract, performs the contract, or part of the contract. Turns out that the contract was unlawful. If it can be terminated, then the usual remedy is to terminate the contract. Of course, if there are special reasons for keeping it going, the road is half built, or in a case which is more pertinent today, somebody needs to pay the social grants, then in those cases the contract may nevertheless be allowed to stay in place. But that's not the situation here. It's not a situation where the road is half built and nobody else can complete the building, nor is it a position where the suggestion that no one other than Mr. Abrahams could do the job competently.
Mr. Butler, your 10 minutes protection
Thank you,
is
Justice
over.
Confefe. So the default position would be, we submit that he too would have to vacate the position, that he's in no different position from any other person whose appointment is found to have been invalid.
Mr. Butler, on this point, may I just inquire? You say that he has been paid, so there's no prejudice. But if he were, if the court were to find that he was appointed unlawfully right from the beginning, now, why is if he doesn't have to, well, I'm not sure why he wouldn't have to repay the salary, but what is then the pension implication for him? Because under what circumstance he would not then be removed under Section 12.8?
Yes.
So what regime applies to him?
Yes. His best claim would be, I'm going to lose some pension benefits. There couldn't be any basis for claiming back the salary he's been paid for the job that he's done. No court would order that, I submit. But there may or may not be a loss in respect of pension benefits. I haven't been into what the Public Service Act and the pension provisions, and I don't know what it is. But that's really with respect to make weight. A man has been in a job for a few years, and he may or may not lose some pension benefits. That's the high water mark of his personal interest in remaining there. And we submit that whatever his merits or demerits as a person and an NDPP may be, there's a fundamental obstacle which stands in the way of the relief which he seeks. The purpose of the judicial remedy is to vindicate the Constitution. And we say that the Constitution is not vindicated if the President has maneuvered the unlawful termination of the NDPP through unlawfully paying him a great deal of money. Secondly, in consequence of this unlawful maneuver or scheme, the President was able to appoint someone else of his choice, Mr. Abrahams. Thirdly, all of this is found to be unlawful, and yet the status quo remains. The order made is, well, it'll remain. Mr. Nkosana's gone, Mr. Abrahams is there, and the only change is that Mr. Nkosana pays back the money. We submit that's not a just and equitable remedy which vindicates the Constitution. It is, with respect, an outcome which mocks the Constitution, because the results of the unconstitutional scheme or maneuver actually remain in place. We say that there would have to be a very compelling reason to allow that, to conclude that that was the just and equitable outcome, and we submit that there is none. And so we submit that there's no basis for an order for keeping Mr. Abrahams in the position of the NDPP. Again, if the President wants to reappoint him, that will be his choice and his decision, not a decision we submit that the court should make. So
you say that, notwithstanding the fact that there is no evidence that he knew that he was stepping into a position which was fraught with problems.
That is so, Justice Kampepe, because that's often the case in unlawful tender cases. The bidder thinks it was all done properly, discovers that it wasn't. That doesn't mean that the successful bidder is entitled to keep the job. The job comes to an end unless there are compelling reasons compelling other reasons why the successful bidder should keep the job. The road is half built, or there's no one else who can do the job. So the question then is, what happens in the interim? Because if there's now no acting NDPP, if there's no NDPP, what happens in the interim? There obviously has to be an interim appointment. And there, perhaps I should just say one further thing about Mr. Abrahams' position before I get there, because there is one further point I want to make, which is why it's not appropriate for Mr. Abrahams to be left in position. And this is that the prosecution of a former president is a momentous matter in any state at any time. And it is absolutely essential that the decision be made by someone in whom the public can have full confidence, so that there can be no reasonable fear or apprehension that the decision is made either to settle political scores or because of favor to the former president or because of an attempt to curry favor with the new authorities. And Mr. Abrahams is now in an impossible and irretrievably suspect position, we submit. Firstly, if he refuses to prosecute, if he's left there and he refuses to prosecute, there will be suspicion that he's done that in order to protect the former president. But alternatively, if he decides to prosecute, there will also be suspicion because many people will ask the obvious question: why only now? Why only now when there's a change of president have you decided that Mr. Zuma should be prosecuted? Are you seeking to curry favor with those who are now in power? Now, those are just natural questions and natural suspicions which will arise. And Mr. Abrahams is in an impossible position as far as that's concerned. And when we now remember that we're talking about the prosecution of a former president and the need for absolute confidence, so far as human beings can have it, that this is being dealt with properly and not for an ulterior motive, that puts his position...
Mr. Butler, the one difficulty with this is that CASAC itself, some time ago, when the position was vacant and the president was dilly-dallying, an application was brought for the appointment to be made by the very same president, Mr. Zuma. When that appointment was made, there would have been questions because the questions have been inherent in the previous presidency. So what your client is submitting in different periods, but on exactly the same facts, is that he is in an impossible position. But in fact, it was precisely because CASAC wanted an appointment earlier on that the appointment was made.
Well, it's with respect to attributing greater power to influence to CASAC than I submit is appropriate. What happened was CASAC said you can't have a situation where you just leave an acting NDPP there forever. That's undesirable. A permanent appointment must be made. What happened after that, one of the things that gives rise to this impossible conundrum is that after Mr. Abrahams was appointed, he resisted the attempt to have the prosecution of Mr. Zuma reinstituted. That's what's compromised him. He resisted it for a long time. And now, as the clock ticks over, he might change his mind. And if he does that, people will say, well, why did he change his mind now? Why did he resist for so long?
Well, but the fact of the matter is that he would have been advised that there were legal grounds to defend the Mshere decision, and those grounds were advanced. The fact that they have been unmeritorious doesn't, neither cuts here nor there. I mean, if the new president makes an appointment, given what the public's been subjected to over the last 10 years, everybody is also going to say, well, the new president has now appointed a person to settle scores with the previous president. Those, in a sense, that's unavoidable in the public perception, and the political context. The point I'm simply putting to you is that it's a really difficult basis upon which this court should be doing its evaluation.
What I'm submitting, Justice Kachale, is that there is no good reason to deviate from the default position, that the chips fall where they may, and the new president makes an appointment. Of course, there will be people who raise questions whomever he appoints, but the chips fall where they may in terms of the default rule, that there's no just and equitable reason to try to keep this game in play, when in fact there are good reasons why this game shouldn't be in play. But remembering where the default and the burden lies. There is a problem, which is about what happens in the interim, because actually other senior members of the NPA are similarly in an impossible position. it's common cause on the papers that there have been factional wars with political undertones in the NPA. If one wants to read that, the references, the statement is made by the Minister and Mr. Zuma themselves. One sees it in the Minister's affidavit, volume 6, page 571, paragraph 5, and in Mr. Zuma's affidavit, volume 13, page 1212, paragraph 91, where it refers to intractable and intolerable conflicts involving the senior management in the NPA. And it's vital, of course, that in the interests of justice, the decision which is made whether to prosecute a former president, and also, if so, how is to be prosecuted. Who will be the prosecutor? We have recent experience in our public life in other spheres of prosecutions which seem to be deliberately fudged in order to achieve an outcome. So it's not just whether to prosecute, it's how, who will do it. That those decisions should be made about a person made by a person in whom the public can have full confidence, to the extent that that's humanly possible. And that the decision should be completely untainted to the...
Sorry, Mr. Butlander, why should the public not have confidence in Mr. Abrahams?
The public can't have confidence in Mr. Abrahams because for the reason that I've given, that he's been sucked into and a principal player in this dispute about whether Mr. Zuma should be prosecuted. He resisted the prosecution. And secondly, he is appointed as a result of the scheme or maneuver, the unlawful scheme and maneuver which the former president adopted. So there will be questions about him. I'm making no statement about his merits or demerits. One can't do so on the papers. But it's inevitable that there will be suspicion. And so there is the difficulty that if the decision needs to be made by a person in whom the public can have complete confidence, and the problem is that I've tried to find a way of expressing this which isn't offensive, but it's difficult to. There are too many people in senior positions in the NPA who carry toxic baggage arising out of the disputes which the president has told you about and which the minister has told you about. And those people will also be subject to suspicion. There's going to be, oh, he's part of that faction. Oh, no, she's part of the other faction. That's why that decision was made. It's very unfortunate, but this is an unusual situation, and the court can't close its eyes to it. So we submit that if an acting NDPP is appointed because Mr. Abrahams doesn't remain and Mr. Nkosana is not reinstated, or the other way around, the decision shouldn't be made about the prosecution until the President has appointed a National Director of Public Prosecutions, and we then move forward and we start off on a fresh foot. That brings me to the question of
and you make that submission in the full knowledge that that could cause another possible delay in the event of an announcement on a prosecution.
Yes.
By well over a year, and cause further difficulties. Because it is an interest of justice problem as well that we face here.
Yes, it is an interest of justice question, Justice Charlie. I submit there's really no reason at all why it should take a year or anything like as long as that. It would be extraordinary if Mr. Ramaphosa has not already given some thought to whom he might appoint. It's hardly he would say, oh, I've got to appoint an NDPP. Let me think about that. I never thought about that before. Names are bandied around. It wouldn't need to take 60 days, and nor would the new incumbent need to take a long time in order to make the decision. The reports will be there, the documents will be there. Not so difficult. So there will be delay. But there has been extensive delay, terrible delay. And it's worth suffering a slightly further delay in order to try to get the process right. When one considers the consequences of getting it wrong.
So you are submitting that the delay would be justified in the circumstances?
That is so, Justice Kompepe. So that brings me to the question of the confirmation of the declaration of invalidity of Section 12.4 and 12.6. The High Court's declaration of invalidity is found in volume 15, page 1390, paragraph 129. And there are two sections which are declared invalid. Firstly is there's section 12 sub 4 of the NPA Act. That confers a power on the President to extend the term of office of an NDPP beyond the retirement date. This power, as we submit, is subject to the same objection as was raised to the extension of the terms of the term of office of a Chief Justice in the Justice Alliance case and in the Helen Suzman Foundation case dealing with the extension of the term of office of the head of the Hawks. It's the same principle. It's the principle expressed by the court in its judgment that it's undesirable, it's incompatible with the independence which is required, that somebody should sit in the post and say, well, I want to get another term or an extension. I'll do what the holders of power wish, because that will ingratiate me to them. That's fundamentally inconsistent with the guarantee of independence. That's what's been held in Justice Alliance and Helen Suzman. And the relevant passage in the Helen Suzman Foundation case is quoted in the High Court's judgment, volume 15, page 119, I beg your pardon, page 1387, paragraph 119. And so we submit that that logic and that principle apply with equal force to the extension of the term of office for the NDPP. There's a reason why there's a fixed term of office. We know that fixed terms of office are a characteristic of our Constitution and a healthy characteristic. It ensures independence and it ensures change and it ensures progress. So we submit that Section 12.4 is inconsistent with the Constitution and that Order 1 made by the High Court, that's volume 15, page 1391, paragraph 1, Order 1 of the High Court should be confirmed.
Mr. Butler, sorry, on this point, and you're going to have to bear with us because we really are at a very serious disadvantage of not having any countervailing arguments. And so instead of sort of sitting back, some of these questions may sound like an advocacy, but in the absence of anything else, we are really in a difficult position.
Justice Kachale, may I interrupt you and just deal with that question first? We have given some thought to the problem of the lack of submissions on behalf of the Minister and the President. And we submit that the rule is not that the government must appear to defend the statute. The rule is that the government must appear in order to tell the court what its view is on the statute. That arises from separation of powers concerns. And so the
only point that's being made is that it would be helpful to have submissions rather than, from them as to what the background was, why they may concede the invalidity, but nothing. I mean, it's like they've all gone AWOL.
Yes.
And I mean, that is, for a court to sit in a constitutional challenge and nobody helping us on the other side is just absolutely impossible. It's, in fact, an abdication of duty.
Well, this matter has confronted the court before. It arose in the Darwood case. In the Darwood case, where the respondent was the Minister of Home Affairs, at the last minute, the Minister of Home Affairs withdrew. And the court expressed its displeasure, and it said, that's not right. What should have happened is we should have been told in good time, and we could have, in terms of the Constitutional Court Complementary Act, instructed the Minister of Justice to brief someone to make submissions to us so that we know what is the position of the government and we can understand it and we can interrogate it. It's not that there's a need with respect for there always to be somebody standing up and justifying validity. There are many cases in this court where the government has stood up and said, we agree that it's invalid. And the court said, now we hear you, we understand that. A recent example is Surrogates. But the court does need to hear from the government. We accept that. And so we submit that the appropriate remedy is in what is now section 15 sub 2 of the Superior Courts Act, which deals with confirmation proceedings. And it's 15.2 says, if requested by the Chief Justice to do so, the Minister, that's, as it happens, the same Minister, the Minister of Justice, must appoint counsel to present argument to the Constitutional Court in respect of any matter referred to in sub 1, that's the invalidity. And so we submit that if the court is concerned, and of course the court does have or can have access to the submissions which the Minister and the President made in the High Court. In the High Court, the Minister and the President opposed the declaration of invalidity, and those submissions are available. That was the best case they could put up. But if the Court would like to give the Minister a fresh shot at considering what his position is, there can be no possible objection to that. We submit that the proper procedure then is, or proper mechanism is Section 15.2, in which the Minister is requested to put up, to appoint somebody to put up the government's case, not to necessarily to defend the statute, to say what is the government's case. And we make the submission that if that order is made, we ask that we be given an opportunity to respond to whatever submissions there are, because we won't have seen them before.
Would you under those circumstances, require oral argument to be presented, Mr. Butlander? Or would
My
it
submission
be
is that
sufficient for you to be given an opportunity to respond in writing?
We would be happy with an opportunity to respond in writing, Justice Kempepe. Of course, the Court may conclude, having read the written submissions, that it wants to hear oral argument, but there's certainly no need to do so unless the Court finds it necessary. We would be happy with an opportunity to respond in writing to submissions in writing. So, I'm sorry now, Justice Kachali, I interrupted you, but I wanted to make our position clear on that there should be an opportunity.
Thank you. So if I could just come back to 12.4 for a moment. What the High Court has done is to invalidate the entire section. Now, it seems to me that there are, while the principle of a fixed term is certainly correct from the point of view of safeguarding independence, the section seems to take from the public service a retirement of age of 65. Now, if you invalidate this whole section, that immediately means that anybody who is 56 and over cannot apply for the job. Because if you're 56 and you go to 64 and 65 and you may want, it may be an advantage to have a 10-year pension, well, you simply can't do that because the President is not going to be able to extend your term for so it precludes, in a sense, a whole lot of people, including several people appearing before us today.
Some of them older than 65.
From making themselves available for, for this job. And so that's not a light matter, but as it stands, that's what it would do. The second problem that occurs to me is this, that what frequently happens in these sorts of situations is an NDPP, for example, may be extremely busy, may be involved in a case, may be involved in a complex restructuring process, and has simply not been able to finish his or her work in the time allocated. But because he is now bound by a fixed term that nobody can renew for the best of reasons, the person has to leave midway, compromising whatever work has already been done. So you then have an unintended consequence that for the last 2 years before the person leaves, he or she is going to sit on his hands because they can't take any work take on any more duties that will take them beyond the 10-year period.
So I bet there are two answers to that. Firstly, Section 12.1 is quite clear. Section 12.1 says the National Director shall hold office for a non-renewable term of 10 years, but must vacate his or her office on attaining the age of 65 years. So that's not up for grabs. If you, at the age of 56, you take the appointment, you can only serve for 9 years. The President will know that and you will know that. And that's the cost of being 56. And it's the cost of having a mandatory retirement age. One might argue there ought not to be a mandatory retirement age, but there is a mandatory retirement age. So that's not in play. As to where there's cases of good reasons, there may be good reasons, of course. There may be very good reasons in a particular case why it would be a good thing if the incumbent stayed on. But the same applies to the incumbent Chief Justice, and the same applies to the incumbent Director of the Hawks. And this Court has held that that's simply impermissible to have an optional extension at the instance of the executive because the costs are too high. It may be that you lose some benefits, that you lose somebody's services for a year or two whom you would have liked to have. But the cost to the potential cost to the independence of these critical institutions is such that this Court has said twice we won't countenance that. The Constitution doesn't countenance it.
Well, I should say that certainly the court has ruled that way in relation to Chief Justice, but when it comes to judges, there's a provision for judges to have their terms extended if they haven't completed the 15 years and they want to go on for another 2 years.
Yes.
So even as far as the independence of the judiciary is concerned, there are provisions which allow the minister to extend.
Yes, there are, but there's a cap on it. And it may be that Section 12(4) could be rewritten to create a possible extension with a cap on it, and then the court would have to decide whether that's permissible. But this extension, which is for an extension for any period up to 2 years, there's a cap here too, is we submit impermissible. It's impermissible in terms of the judgments of this court in Helen Suzman Foundation and Justice Alliance. Then the second challenge is to Section 12(4), to 12(6), I beg your pardon. 12(6) deals with the suspension of an NDPP, and it empowers the President to suspend an NDPP unilaterally, indefinitely, and without pay. That sort of provision was considered by this court also in the Helen Suzman Foundation case, and it was found to be inconsistent with the requirement and guarantee of the independence of the head of the Hawks. Then it was considered again, a similar approach in McBride. There again, that was dealt with the executive director of IPID. Again, a provision of this kind was held to be inconsistent with the guarantee of constitution. In McBride's case, there was even provision for payment during that. There would be payment during the period of suspension. But even then, this court said, the High Court said, and this court said, this provision for indefinite suspension and without any process can't stand. And so we say the same applies to Section 12(6) of the NPA Act. There could hardly be clearer and more binding authority of this court on the question. We submit that in this court, that in this instance, if there is a declaration of invalidity of 12(6), some interim relief is necessary, because there may be situations in which it's necessary to suspend the NDPP. And so there's interim relief which was provided by the High Court. If I can just give the court the references, it's paragraphs 2, 3, 4, and 5 of the High Court's order, where the High Court carefully carved out what part was offensive, and then put in place an interim remedial arrangement. It's volume 15, page 1391, and we submit that those orders of the High Court should be confirmed.
Mr. Budlander, a couple of questions then on 12(6), and I put these questions to you in full, having read both Helen Suzman and McBride. As far as the unilateral suspension is concerned, that of course must be read subject to procedural justice. So that has to be read subject to Audi.
Well,
perhaps I should just go through each of my difficulties, and then you can respond. As far as the indefinite suspension is concerned, it is a suspension which endures only as long as an inquiry hasn't kicked in. Surely that doesn't make it indefinite. I mean, the president or whoever would have to exercise the power to hold an inquiry within a reasonable period, within a reasonable time period, on pain of a mandamus. So it's not quite an indefinite suspension. And third, the problem of a suspension without pay. Again, you know, the sort of specter of the last 10 years hovers over this. But as much as this may be difficult to assume for a moment an honest president, and assume for a moment National Director of Public Prosecution, who, for example, on good grounds, has been found to have taken an improper inducement. Why should the public purse be saddled with having to have that person paid indefinitely, as it were, while the suspension while the suspension lasts. If there were no good grounds, if there were good grounds, in fact, to suspend the person in the first place. It may, of course, be that a proper safeguard would be that in the event of a suspension without pay, that the President should table that or the reasons for that before Parliament. But there are ways of dealing with that other than having to guarantee in every circumstance an NDPP a guaranteed salary, regardless of what the circumstances of the suspension may be. And it seems to me that may well be what the drafters had in mind when they put that particular provision in.
Yes. Justice Kachale, to respond to the three issues you raised, firstly, as to the procedure, the right to a hearing, the difficulty with that contention is the Masetla decision to judgment of this court, where it was held there was no such right. Now, it may be that it's different in the case of the NDPP, and one day that case may get to be argued. But the Masetla judgment provides some authority for the proposition that there wouldn't have to be a hearing. We don't know what the consequence would be, what the law would be in relation to the NDPP. It would be a brave person who'd predict it with certainty. Secondly, as to the indefinite nature of the suspension, yes, what we propose and what the High Court has accepted as an interim arrangement, pending Parliament deciding what should be done, that there should be a maximum six-month period. That 6 months should be enough to deal with whatever is necessary. Of course, if the court declares the Act invalid and puts that interim arrangement in place, Parliament will have the opportunity to decide in due course, no, it shouldn't be 6 months, it should be 3 months or it should be 12 months. But some interim arrangement needs to be made. What is the indefinite? What is currently is the position is it's indefinite, and that we submit is impermissible. Mr. Pikoli was suspended for more than a year, and so we know that it can happen. This is not a fanciful fear, and so as far as the indefinite period, yes, there are arguments that can be made as to what the period should be. 6 months seems we submit to be an appropriate starting point. Parliament can decide what it should be in due course. If it decides a very long period, there's maybe another challenge. If it decides a very short period, there won't be. Then as far as suspension without pay is concerned, yes, again, there may be circumstances in which suspension without pay could be justified, depending on the circumstances and depending on the procedure which is followed. That's a matter for Parliament to deal with and to decide when will a suspension without pay be permissible. But the default position we submit comes from this court's judgment in Helen Suzman Foundation, which there's the judgment of the Chief Justice, where he said this is punitive, what happens. It's punitive, and it's punitive without ever having been found guilty. Now, the consequence is you may have somebody who really is guilty and gets paid for a period. And perhaps there are ways of dealing with that, and Parliament can choose to deal with it. But the starting point must be that you can't have a situation where an NDPP knows that if he or she steps out of line, he or she can be suspended without pay at the discretion of the President for as long as justice may take time to be, as long as the President may decide what to do about it or the inquiry may take place. It's a punitive measure, and that infringes the guarantee of independence. It would induce any sensible NDPP faced with a difficult decision, a very controversial decision, to say, I wonder whether this is going to get me suspended. And if I do get suspended, I wonder whether I'm going to get paid. The precedent of Mr. Pikoli as far as suspension is not a happy one. He was paid. That is so, Justice Drifter. As long as he wants, Justice Drifter. That is so, Justice Drifter. It's really the two sections are incoherent, and they're out of step with one another. And no doubt it's possible to legislate a permissible suspension regime, but this suspension regime is impermissible. Justice Kampepa, unless there are further questions, those are my submissions.
Thank you, Mr. Butland. Yes, Mr. Du Plessis.
Thank you, Justices. For the reasons already advanced by the other parties, the HSF contends that both the legislative machinery and the exercise of the public power by the President in this case fell short of the level of adequate independence demanded by the Constitution. But the HSF goes further. It wishes to submit that through the lens of international law, CASAC's constitutional challenge to the sections of the NPA Act must prevail, and moreover, that in framing the just and equitable relief in this matter, our international law obligations oblige us to come somewhere towards a just and equitable relief that meets the international standards, and we wish to make brief submissions thereon. We would then make submissions in the following three ways. First, just briefly framing the international law and its residence within the constitutional scheme, very briefly, obviously. Secondly, the international law demands for independence. And then thirdly, the impact of those demands on the provisions in question and the relief. The HSF respectfully submits that this court is enjoined to consider South Africa's international law obligations. Our constitution embraces international law, and I certainly don't need to take the court through its own decisions where that's made clear in the torture docket case, as well as in Glenister. But we might just lift out, with respect, four principled commitments and their practical consequences that arise from the embrace of international law. The first is that South Africa has signed and ratified the 6 treaties that it references in the HSF's heads of argument. It means that both the executive and the legislature have committed to be bound by those provisions under international law. Secondly, and flowing from that obligation, is that South Africa's failure to observe the provisions of those treaties could result in it incurring responsibility towards the other signatory states. Third, the legislature has enacted those instruments into our domestic law through PRECA. And fourth, and perhaps most importantly, our responses to corruption are not only therefore to do right by the Constitution, our responses locally resonate globally. As this court has emphasized in the torture docket case, our country's international and domestic law commitments must be honored. And as the court said, we must take up our rightful place in the community of nations with its concomitant obligations. And all of this conduces to the following, and here I'm with respect paraphrasing what Justice Cameron has written extracurrially about what was decided intracurrially in Glenister. He wrote that in the Duke Journal of Comparative International Law, where he made the profound but ultimately important point for the purposes of this court's determination, which is that the constitutional scheme cannot mean that the executive could proclaim and act in accordance with one position at the international level, but adopt a different approach within the domestic arena. With that introduction, may I then briefly lift out the demands of international law pertinent to this case?
With that introduction, Mr. Du Plessis, your 5 minutes protection is up.
My 5 minutes projection is up.
Yes.
Protection, thank you.
Protection.
We submit that our international law commitments reinforce and enrich our understanding of independence in the following way, Justice Kempepe. Articles 11 and 36 of the United Nations Corruption Against Convention impose an obligation on this country to guarantee, and the words are used, the necessary independence of all bodies tasked with combating corruption. Article 26 says that the members of the justice system, which of course must include the National Director of Public Prosecution, must be protected from intimidation and interference. And Article 20 sub 4 of the AU Convention reinforces that independence in even more direct terms. It says that the national authorities or agencies shall be allowed the necessary independence and autonomy. Now, the need to comply with those demands and safeguards, we submit, is especially acute in the context of potential undue influence by the national executive. In this regard, we've quoted in our written submissions from the OECD report in our heads of argument. It has drawn criteria from the United Nations Convention Against Corruption, and it has drawn the best practices from a number of states in that report. And if we may lift out 3 principles with respect, which we say resonate helpfully for this court, from the OECD's report. The first is that independence primarily means that anti-corruption bodies, which of course must include the NDPP, must be shielded from undue political influence, and that is secured through institutional and legal mechanisms aimed at preventing undue political interference, as well as promoting preemptive obedience. And in short, the independence therefore entails depoliticization of anti-corruption institutions. Second, and relatedly, that independence requires careful consideration in order to limit the...
Right, just taking a break from the ConCourt there, we're hearing the future of the NPA boss Shaun Abrahams, which is under the spotlight at the ConCourt, as well as the matter of the former NDPP, Ngolisi Nkosana. So essentially, the ConCourt hearing two arguments today. One is the appeal by Shaun Abrahams against the High Court ruling, which declared his appointment to the post invalid. The other is from Ngolisi Nkosana, the former NDPP, appealing the High Court's refusal to accept a late affidavit that he filed, which he says denied him access to fair justice. So remember, this dates back to 2015 when the court found that former President Zuma had unlawfully removed Nkosana from office.
The OECD report stresses that. It's also a requirement which has its own mooring in this court's jurisprudence in the all-pay remedy decision, where this court said that all just and equitable relief has to be tailored to the context and obviously to the facts of the case. The OECD report says, in this respect, importantly, three things. It says, in contrast with other illegal acts in public corruption cases, at least one perpetrator comes from the ranks of persons holding high office or public office. And the higher the function, the more power that person has over other institutions, and by corollary, the level of independence therefore required is clearly linked with the level of corruption and the height that that individual may occupy within the public station. So the report goes on to say that tackling corruption of high-level officials, or systemic corruption in particular, is destined to fail if efforts are not backed up by a sufficiently strong and independent institution, which must feature in the understanding of what adequate independence means within the international law obligations. It's captured best at page 26 of the OECD report, which says the following. If I might just briefly quote it to the court, it says, "It is the responsibility of individual countries to find the most effective and suitable institutional solution adapted to the local context and the level of corruption involved." And in light of that, we respectfully submit that it's clear that the statutory framework in place must ensure that the NPA is, of course, sufficiently independent, that it has adequate structural and operational autonomy to mitigate undue political interference. But here's the crucial point. It needs to be responsive to the nature and the extent and the level of corruption that is taking place within a particular country, particularly as our history now tells us, where such interference may come from the most senior members of the executive. So given those international duties adopted by South Africa, we respectfully submit that in the fight against corruption, sections 12.4 and section 12.6 of the NPA Act cannot stand. The debate has been had between certainly Justice Kachalia and my learned friend Mr. Budlander about the effect of this court's findings in relation to those two provisions. We would simply submit, understanding that, of course, there needs to be perhaps further submissions made in due course by the government. We respectfully submit that that's not necessary for the reasons that Mr. Budlander has suggested. But to the extent even that the court wishes to have those submissions from the government, at the outset, it would be important for the court to reflect in its decision, either now or in due course, that international law requires the highest standards of independence in relation to both sections 12.4 and 6, and read through the lens of sections 12.4 and 6, it would not be permissible for those provisions to remain on the statute books. The debate about what they might look like in terms of the remedy is perhaps for some a later day, certainly through Parliament, but as they stand, they certainly are suspect. If I might turn then briefly to the just and equitable order, because that's where we say international law has continuing relevance as well. And we'll conclude our submissions briefly on that score. I'm aware, Justice Kompepe, we're heading towards lunch. There's a debate before the High Court and this court about whether Mr. Abrahams should vacate his office or not. And whether Mr. Nkosana should be reinstated is something we've made our submissions on in our written submissions, and they're best left to Mr. Nkosana to address. We've seen the debate between the court and our learned friends about whether there is another mechanism perhaps open for the court to allow for Mr. Nkosana to, in essence, vacate his position and somebody else to be appointed in his place. We leave that in the court's hands. We see that that is a permissible option, and we, at the end of the day, see that there are various means by which just and equitable relief might be granted, and we understand that there may be, in this context, particular debates to be had about that. But in the time left, I would merely stress that our international law obligations, together with our constitutional ones, certainly leave this as a residing feature of the remedy, which is that it cannot countenance Mr. Abrahams continuing in office. So whatever else the court may decide, we would submit that our international obligations make it clear Mr. Abrahams cannot remain in office. And that is because of the demands of independence, going not only to our laws and institutions, but with respect, this is an important point highlighted again through the international obligations. Our independence demands also go to the persons that occupy that position. And we would respectfully submit that for 2 points, Mr. Abrahams cannot continue to occupy that position in light of the demands of international law. First of all, we submit that our international law obligations require, like our Constitution, a result that underscores the imperative of non-interference in our anti-corruption units. That is because, as the OECD report stresses, and I'm quoting from it, independence, first of all, entails the depoliticization of anti-corruption institutions. And it is incumbent on South Africa and this court, with respect, to be responsive to the context of corruption more broadly, and to the manner in which, in this case, Mr. Nkosana was encouraged to leave office, and Mr. Abrahams took up the place in his stead. And in this case, the President, with respect, abused his powers. As Mr. Trengrove put it, he both bullied and seduced Mr. Nkosana in order to clear the way for Mr. Abrahams. And with respect, it's irrelevant whether Mr. Abrahams is complicit in this scheme. Even if one assumes that he was a mere pawn, the fact that he became the beneficiary of that political or executive abuse is enough. And in order to vindicate the Constitution and international law, it's necessary to undo that benefit for the reasons that have already been given. Importantly, the second point is this. Flowing from the idea that international law requires South Africa to be responsive to its own level of corruption and the nature at which it takes place at the highest levels, it is imperative that there be no taint in respect of the NDPP, in the person of the NDPP. His independence, real and perceived, must be beyond taint. We know that this court highlighted in Glenister and McBride that public confidence that an institution is independent is a component of, or is constitutive of its independence. So it's not just whether Mr. Abrahams is independent, it's whether he's reasonably perceived to be so, and this court said as much in Glenister at paragraph 207. We also know that independence requires, again, as the OECD report stresses, that careful consideration must be given to ensure that there is nobody within the chain of hierarchical structure who can interfere in crucial or operational decisions, such as the commencement, continuation, and termination of criminal investigations and prosecutions in a way which gives rise to a reasonable concern about that person's independence. Yet we respectfully submit that there are at least 3 reasons to think that there is a reasonably perceived taint in respect of Mr. Abrahams' independence. The first reason is that there is a perceived abandonment of his independence arising from the findings of the Supreme Court of Appeal in the spy tapes decision in Zuma. And we've quoted in our heads of argument at paragraph 82, where the court said it's difficult to understand why the present regime of the NPA, which was of course headed by Mr. Abrahams, considered that the decision to terminate the prosecution of Mr. Zuma could be defended. The second reason is that similarly, the High Court in this case held that Mr. Abrahams had associated himself on all material issues in that litigation with the position of the President, and that such was inconsistent with the imperative of prosecutorial independence. And third and finally, Mr. Abrahams has been severely criticized by the High Courts for protecting Ms. Jibba, who we know from these papers in this case is involved in the factional wars supposedly taking place in the NPA. But importantly, a full bench of the Pretoria High Court last year found that Mr. Abrahams' conduct in defending Ms. Jibba in the face of binding and damning findings against her in highly charged political cases, and who has been struck from the role of advocates, raises serious questions of credibility and was bizarre in the extreme and lax integrity. Now we respectfully submit, and we do so with a sense of urgency, that we're not asking the court to decide the correctness of those findings. We're not asking this court to confirm that those findings are correct. It's enough, we submit, that the findings have been made, because the public perception and the perceived impact on independence arising from them is, we say, overwhelming. The pivotal role of the NDPP... Mr.
Du Plessis, is it necessary, if we find that the appointment or the resignation wasn't a resignation and there wasn't a vacancy, and that that follows, is it necessary for us to say anything about Mr. Abrahams' competency? If we simply say the post is open, he's not he doesn't continue it, and the new president must appoint a new national director of public prosecutions.
Justice Froneman, it would be necessary for two reasons with submission. The first is that because the court would have to deal with the question of just and equitability. So if the default position is that Mr. Nkosana is out, then the debate is, well, does Mr. Abrahams continue to remain in office? And we submit there are very compelling reasons why he should not. And some of those reasons would engage these inquiries as to what the public perception is in respect of his independence.
But Mr. du Plessis, you know, Mr. Abrahams, as a result of and because of the way that the case was pleaded and argued, wasn't required to defend himself on any of these allegations, because it was specifically said that you know, as a matter of law, the default position should be applied. In the light of that, he didn't feel it appropriate or necessary to deal with all of those questions in any sort of detail. Is it really fair now for us to sort of, in the first instance, to say the default position applies, and B, if he now leaves, we add the added taint in circumstances where he hasn't been really properly allowed to defend himself?
The first answer, Justice Castrale, is the one that Mr. Budlander gave, which is that he knew that there would be a potential for him to have to show evidence as to why, despite the ordinary position under the Constitution, which is that if the vacancy arose ultimately unlawfully, whether he would nevertheless be entitled to remain in office. And so he had the opportunity to provide whatever evidence he wanted to. And as Mr. Budlander submitted, the evidence is skimp. But there's a separate point, which is it's not about him being able to show that he's fit and proper. In answer to the second point that I was trying to make to Justice Froneman, it's not about him being able to show that he's fit and proper such that he must remain in office qua Section 12 of the NPA Act. The debate is about whether in the context of this case, remembering the importance of recognizing that context does have some very important role to play in relation to remedy, whether in the manner in which he came to be appointed and ultimately his conduct, severely criticized not only by the court in this case but by other courts, allows there to be a position where he says there is no reasonable perception that I am not independent, quite the opposite, I'm reasonably perceived to be independent. We would respectfully submit the debate is specifically because of the international law demands about independence, driven through
more directly, Mr. du Plessis, was he called upon to answer even that perception?
No. No, Justice.
Then the question by my colleague, Justice Kachalia stands.
Well, it doesn't with respect, because the debate isn't whether he had an opportunity to respond to. This is not an employment dispute between a private person and somebody that is being dismissed from private employment. This is a question about the person who holds the highest office.
If the case is you cannot remain in office because there are these perceptions about you, that case must be pleaded, so that he's given an opportunity to answer even the very question whether there are indeed such perceptions, or if there are, why they are not relevant to the question of him staying. That's the point of substance that my colleague is raising.
No, we understand the point of substance, Justice Madlanga. The difficulty in this case is that it's not a question of substance. It was never an issue on the merits, but it was an issue of the remedy. The moment it became clear that Mr. Nkosana and the settlement agreement may be undone because it was unlawful, then there had to be a debate about what the court was going to have to do under Section 172(1)(b) about whether it kept Mr. Abrahams in or not. And it is at that level that the question of perception becomes integral. And the High Court below was perfectly comfortable in saying that the manner in which Mr. Nkosana identified himself with the President's conduct in that case, in other words, supporting the idea that the settlement was Mr. Abrahams, that he supported that particular outcome. All of those debates were traversed in the High Court, and the High Court said the manner in which, in that case, Mr. Abrahams had identified himself with President Zuma was cause for significant concern. So it became a part of the remedy debate. It was never before the court as a merits issue, but certainly it was as a just and equitable consideration. And our submission is that that just and equitable...
It must be extraordinary if we are going to convict a person on the basis of his arguments and the perceived friendships and alliances. I mean, the legal submissions he made were legal submissions. He didn't say, I support the President in all his mendacity, that issue didn't arise at all. So, I mean, they were advancing proper legal arguments that were either good in law or bad in law. To elevate that to aligning with the President in all respects is, with respect, not fair.
Well, that's what the High Court found, Justice Kachalia. But in addition to that...
Saying that then the High Court was not justified in that finding.
In addition to what the High Court found, though, Justice Kachalia, is that, of course, there are the different decisions by the courts separately, which have been highlighted both by the High Court and, of course, by the Supreme Court of Appeal. Those together are significant considerations which speak to the importance of whether Mr. Abrahams is reasonably perceived to be independent in the matter. And he's at least reasonably perceived to be, with respect, inadequately independent to fill a position which demands adequate independence. So for those reasons, the Helen Suzman Foundation submits, alongside CASAC, that there are significant concerns at the level of just and equitability arising in relation to Mr. Abrahams' independence. And if I might then conclude, recognizing that lunchtime has already come, Justice Kempepe, that Justice Jafta, they don't arise in this case because the debate is, Mr. Nkosana, was he lawfully able to resign in the manner that he did? If not, then the court has to say that he wasn't unlawfully vacating his position. The only debate then is whether Mr. Abrahams must be entitled to stay on. It's a just and equitability debate. It's not a debate whether Mr. Abrahams must still go through the Section 12 inquiries as to whether he's fit and proper. The debate about whether he's entitled to stay in the position at all arises purely from the fact that he happens to be in that position because, in those consequences, Mr. Zuma appointed him to the position, but appointed him unlawfully, arising from the unlawful vacancy that arose.
So the argument is that those protections don't apply to him.
No, and I don't think anybody suggested that they apply to him, because the debate is he wasn't lawfully entitled to that position at all. The status quo needed to be restored, and Mr. Nkosana needed to be placed in the position of the NDPP. If that's the position the Constitution requires must be vindicated, then the only debate left is what to do about the factual result, which is that Mr. Abrahams happened to have been appointed. The factual result of Mr. Abrahams having to be appointed, it's, as Mr. Butler said, it's like the tenderer, the innocent tenderer says, well, I had nothing to do with this, or maybe I did, but I'm entitled to keep the money or stay on. The debate then is no, you don't, because the Constitution must be vindicated. You don't need to be undone through your position as a tenderer, through any other provisions under the tender provisions of the PFMA. You just are no longer the tenderer, because the original tender was unlawful. That is the consequence of objective constitutional invalidity, Justice Jackson. Okay.
Well, it's cold comfort to a litigant if a court impugns his integrity on the first leg of the argument or the second leg of the argument. Fact of the matter is it impugns his integrity, and if Mr. Abrahams is to leave with findings like that from a court like this, the prospect of his subsequently being employed is virtually nil.
But they're not findings, with respect, Justice Kachalia. They are not findings in as much as they are recognitions of judgments in which other courts have found this about Mr. Abrahams. So it's not that this court, as I was attempting to stress, it's not as though this court needs to make those findings. It needs to all it needs to do is recognize that those findings have been made, very serious findings, about Mr. Abrahams and his independence. And in light of those findings stack up. They weigh on the scale against an order which allows Mr. Abrahams, through just and equitability, to remain.
And your preface was that gives rise to him being either tainted or perceived to be tainted. So one cannot make light of that.
No, it's either that, and we stand
and can one avoid that we would, in essence, be making a finding/holding on that?
No, because all it would be is a debate about whether there is a reasonable apprehension of independence. And in light of the judgments, and in light of the concerns expressed by the High Court itself, there is a concern about the reasonable independence. We put it no higher than they weigh on the scale against Mr. Abrahams. There are other reasons, the most important of which is that the Constitution and international requires that there must be a vindication of the constitutional wrong, which is that Mr. Nkosana did not leave lawfully, so therefore Mr. Abrahams cannot be in the position lawfully. That is a fundamental proposition, and we submit that independence of international law and the Constitution requires that outcome. But in addition, there are these further factors, and we put it at that.
And not to be misunderstood, I too, talking about findings, I'm talking at the level of perception. I'm not talking about a finding that he is tainted. So just to be...
I think we may agree. If I might just conclude...
Mr. Du Plessis, before you conclude.
Sorry, Justice.
If I understood Mr. Trengrove correctly, he said his position was he was not pushing for the court to make a finding whether or not Mr. Abrahams was fit or proper to hold that office.
No, and neither do we. We're not asking for that finding either, because we're not saying that Mr. Abrahams needs to go through Section 12 for purposes of a decision whether he must remain in his position or not. Not at all. It's a two-step approach. He's not in his position because Mr. Nkosana was not relieved of his position lawfully. So the consequence of objective constitutional invalidity is that Mr. Abrahams and Mr. Dr. Ramahite and anybody else afterwards couldn't lawfully have kept that position. That's the first proposition. But the second then is that in asking the question of whether Mr. Abrahams has any arguments in favor of staying in the position despite that default point, one of the considerations is that he would have to overcome the fact that there are very significant concerns around his independence arising from judgments, final judgments. And that is the point that we make, Justice Turan. If I might conclude just by perhaps offering a measure of assistance.
For the second time now, Mr. Du Plessis.
Yes, I've attempted to conclude twice. This will be my third attempt, but I promise Justice Kampepe it will be the final one. There was a debate between our learned friends earlier, and I think it was in particular Justices Jafta and Madlanga, about what to do about the implications of a finding that Mr. Abrahams is not in the position. What about all the decisions that he may have taken? What happens to those? If I might just give to the court this court's decision in the Democratic Alliance versus the President of South Africa, that's the Simelane decision, also dealing with the National Director of Public Prosecutions. It's 2013, Volume 1, SA 248, CC, paragraph 93, where the court specifically said, the invalidity of Mr. Simelane's appointment will not by itself affect the validity of any decisions taken by him while in office as the NDPP. This will mean that all decisions made by him remain challengeable on any ground other than the circumstance that his appointment was invalid. And this court, in its order at paragraph 4, did just that. Those are our submissions.
Thank you, Mr. Du Plessis.
Thank you.
I think this will be an appropriate time to adjourn for lunch. We should be back in court at 1:30. I see that that doesn't go well. It doesn't go well with my colleagues. Shall we return to court at 1:45? Thank you.
It's slowly. It's faster. One job.